Hello and welcome to this webinar on the Employment Relations Authority and what to expect as an employer as part of Employers Assistance's pre-recorded webinar series. My name is Kent Duffy, lead solicitor and senior employment lawyer here at Employers Assistance. In terms of an overview for informing this webinar's key discussion points, we will be looking at early dispute resolution options, including without prejudice options and mediation. Then on to looking at the Employment Relations Authority itself, including understanding the process and how costs work in the Employment Relations Authority as well. Then finally, onto a number of practical considerations that employers should have front of mind when embarking or considering defending actions or commencing action in the Employment Relations Authority. Early dispute resolution. While this is not directly relevant to understanding how the Employment Relations Authority works, early dispute resolutions and the option for these are nevertheless useful considerations and/or tools that employers will encounter when dealing with personal grievance claims and/or employment relationship problems. In terms of without prejudice options, broadly there are two options for this, either during employment or post-employment. So for setting up a without prejudice meeting or correspondence during employment, there are a few key considerations an employer needs to have regard to. Generally, this is that there needs to be a live or genuine problem or a risk of litigation between the parties, something documented basically that warrants as a basis to set up or move conversations into an offline or off the record discussion, whether that's in writing or via physical meetings, which proceed on an off the record basis. So an employer needs to exercise care if they're going to initiate without prejudice conversations during employment. So usually you'd set up an off-the-record meeting, which are based on live issues during employment to discuss an agreed exit or full and final resolution, these sorts of things. If in doubt, seek advice is the short point to make there if you're unfamiliar with how to set those sort of conversations up to ensure that they remain protected. Post-employment, typically off-the-record discussions would occur within this context between the employer and the employee's representative to resolve personal grievance claims or problems pre-mediation or pre-litigation. Mediation, so that's the step before the Employment Relations Authority. Generally, mediation is voluntary. So during employment, the parties can voluntarily agree to attend mediation, and the same even post-employment where claims are raised. The Employment Relations Authority does have the power to refer matters to mediation, and that's still voluntary. So whilst the party can decline it, it's always recommended that the employer attend to ensure that no dim views or perception is painted otherwise. And then the authority does have the power to direct mediation or basically mandate compulsory attendance at mediation if it deems it to be appropriate. It's important as the employer to be conscious that mediation is the primary problem resolving mechanism that's encouraged under the Employment Relations Act 2000, and it is a very effective forum for resolving employment disputes. So mediation should really be your first port of call if you're unable to resolve things outside of direct discussions or without prejudice conversations. And there are various practical reasons for that, one being that litigation, particularly having disputes filter through into the Employment Relations Authority and beyond, is very expensive, time consuming, and a drain on resources. So there are these sorts of practical considerations that filter into these points that employers should have some meaningful regard and consideration to. So what is the Employment Relations Authority? The authority is an investigative body that has the role of resolving employment relationship problems. The authority hears claims associated with employment disputes and issues determinations. The determinations that the authority issues are legally binding and can be found on the authority's determination database. By way of remedies, the authority has the power to award various remedies, including reinstatement, that's putting an employee or ex-employee back into their job, reimbursement for lost wages, injury to feelings compensation, legal costs, compliance orders, penalties and interests, amongst other matters. So generally you see these sorts of awards where an employee has been dismissed and the employee raises a personal grievance claim for unjustified dismissal and or unjustified disadvantage, etc., and then seeks to have the matters resolved by way of an order or determination by the Employment Relations Authority, and will seek the applicable remedies in order to do that. Understanding the process in the Employment Relations Authority. So employees, employers and unions can apply to the authority if they cannot otherwise resolve their employment problem, which are commonly personal grievance claims. In terms of the process, it typically starts with the applicant filing what is called a statement of problem, along with applicable supporting information or evidence. There is a filing fee for that, $71.55. And from there, the Employment Relations Authority will notify the respondent, whoever that party is. Usually it's the employer party. And from there, the respondent has 14 days to file what's called their statement and reply and supporting information or evidence. If the respondent does not file a statement and reply, then it's important to note that the process may continue in absence of the respondent's participation, and any orders may subsequently be to the detriment of the respondent if they have not given their feedback, response, or position in respect to the various problems which are generally noted in the statement of problem. So it's always encouraged or recommended that the respondent participate in the process and not simply ignore the commencement of proceedings. Otherwise, they do that at their own peril, essentially, or risk. The respondent can, of course, request more time to file their statement and reply, and that's generally recommended as often the issues are complex and it does take quite an amount of time to prepare a thorough and well-informed statement and reply. So there's always the option there to simply request an extension if the employer party requires more time to get their statement and reply organised. If the parties are yet to attend mediation following the commencement of legal proceedings and the submissions of, or lodgement rather, of the statement of problem and statement and reply, then usually they would be referred or directed to attend mediation by the Employment Relations Authority. So the parties would have the option to talk through the issues there and see whether resolution can be achieved at mediation, of course with the benefit of an independent mediator to help facilitate the discussion. Failing resolution at mediation, well then it's up to the applicant, but they would be notifying the authority to continue with the process. So at that point, generally a case management conference is scheduled, and typically this occurs via phone. Usually only the representatives for each party attend the case management conference, and the purpose of it is really to clarify issues or get the issues straight concerning the claims. So what really at the heart of the issue, and what does the authority need to investigate and make orders on accordingly. It includes, what the parties are to expect at the investigation meeting, which, for want of a better term, is the hearing. It's called an investigation meeting, and that aligns with the authority's investigative purpose or being an investigative body. So the terminology in the process is distinct in that regard. It's an investigative forum, not a typical court or formal court process. So that's just something to be mindful of too. Then the case management conference really just deals with practical considerations around the timetable for any key steps to occur beforehand, including the filing or lodging of additional documents, evidences, identifying any witnesses, and the time and the date for the investigation meeting, these sorts of things. From there, the authority will generally provide directions on the next steps, which will, in summary, set the process down by way of the steps required to get the matter towards a determination. So like I mentioned, ultimately an investigation meeting or hearing is set down or scheduled, and the process is essentially an investigatory process. Each party has the opportunity to present its case as per, generally what's been lodged in the documentation, being the statement of problem and the statement in reply. Witnesses may also be called to attend, and they may be summoned too, and they may be asked questions by the Employment Relations Authority member and or cross-examined, including by the parties' representatives or lawyers or advocates where applicable. So it's not as formal as a court hearing like I mentioned, but basically it's a structured forum for the parties to speak to the issues, set out their respective position, their claims and their associated arguments, including being questioned by the Employment Relations Authority member on matters of relevance. The parties will be asked to swear or affirm that the information and evidence provided is the truth. And at the end of the meeting or the investigation meeting, each party may be provided with the opportunity to sum up their case and or provide further legal submissions if relevant. Once the authority member has all of the information, then they will make their determination or their decision. Understanding how costs work in the Employment Relations Authority. So the authority has the power to award various remedies, as I mentioned before, including for costs. So if you're the successful party following the determination or an outcome in the Employment Relations Authority, then you're entitled to claim for costs for professional representation and reasonable disbursements. You cannot claim for your own time or trouble preparing your case, including attending the investigation meeting, but you can ask the authority to award costs for any professional fees or legal fees that you've incurred as a result of defending or commencing the action in the Employment Relations Authority. It is useful to note that you cannot recover costs associated with going to mediation. So it's only typically costs following an unsuccessful mediation that can be pursued by the successful party. The authority member has a range of options that it can apply when determining the issue of costs. So generally they come down to either a cost lie where they fall scenario, and that's basically where the authority determines that the circumstances really warrant each party paying their own respective costs. So cost lie where they fall. Or the ability for it to award costs to the successful party. So the caveat or big thing to be wary or mindful here for any party contemplating litigation in the Employment Relations Authority is that usually the authority will only award a contribution to costs, not all costs, based on what's called the authority's notional daily tariff. And basically what this means is that costs are capped or typically capped as per the authority's daily tariff approach to costs. So the numbers there are on the slide, but that's $4,500 for the first investigation meeting day, and then $3,500 for each additional day any investigation meeting requires. So typically, matters would be resolved in sort of, 1 to 3 days, and that would inform the ability to recover costs on that basis, depending on how many days the investigation process requires. Other factors may inform costs, like whether there was an operative settlement offer, like a quarter bank offer, say, and whether that was rejected, the conduct of the parties, whether these things can result in an uplift or increased costs, etc. So there are some other considerations that filter into this, but generally, like I said earlier, the ability to recover costs are as per the authority's daily tariff. So it's important to note that, because even if you are the successful party, it is highly unlikely you'll be able to claim or recover all of your legal costs. And if you're engaging expensive lawyers, that may be a big difference between your actual legal bill and what you're able to recover by way of the applicable tariff rate. In terms of closing, a few practical considerations for employers to have regard of when contemplating commencing or defending litigation in the ERA, or the Employment Relations Authority. So generally, determinations are a matter of public record, and sometimes they are reported on. So in the various news media outlets, etc. You can see case summaries reported on and also spoken about at forums, employment law forums, and the like. So So unless the Employment Relations Authority grants a non-publication order, which is generally very rare and only occurs in very limited circumstances, the default position is that generally, it will be a matter of public record and anybody will be able to find that determination. I come back to the employment law database, the ERA's determination database, rather, that I mentioned earlier in the webinar. As a result, there can potentially be brand and reputational considerations at stake depending on the nature of the claims. The more contentious the claims and the more likelihood of them being successful, then the bigger the reputational and brand consequences that may be at stake as a result. So these things sort of need to be front of mind and weighed up too as a practical piece when looking at these sorts of things as an employer or as an employee as well. The process also can involve a lot of time. It's hugely labour intensive, dealing with proceedings. It does require a lot of work, things like giving your advocates or lawyers effective instructions, reviewing the documents, and providing all of the applicable evidence and information to inform defending the case or commencing to. So time, resource, cost, stress, these things need to be weighed up. Some claims, for example, breaches of minimum code entitlements, failing to pay holiday pay or minimum wage, these sorts of things correctly, they can also have other consequences, like being stood down from hiring migrant workers or impacting an employer's accreditation with Immigration New Zealand. So those sort of claims you've got to be even more cautious or careful with because of those sorts of implications. Witnesses may need to be called, so management personnel, that can take them out of the workplace, and it also can be a very daunting process for them to be basically put under examination or put on the stand and ask tough questions by the Employment Relations Authority and or the advocates or lawyers on the other side. So it's something to be, practically mindful of too as the employer. As like I say, a practical consideration. The authority decides the matter for the parties is the final point. So that's an obvious one, but parties can often lose focus or sight of that when they're in the trenches of a dispute. So the authority will decide and impose the decision on the parties. And then what that means is the parties will lose effectively control of the outcomes. A legally binding determination will be issued, and one of the parties, and sometimes both, may not be happy with the outcome there. But that's how it goes. The authority is the decision maker, and the control will be lost if you end up in the ERA to some extent. That brings me back to the piece around mediation, and the key difference there in a mediation context, you're very much in control, albeit that both the parties are in control of the outcomes. So you do have more control to land on compromises and negotiated arrangements that are more palatable or agreeable to you, as opposed to basically having the order imposed on you by the ERA. It's just something to think about practically when looking at these sorts of issues. Thank you for your time today, and I hope you've enjoyed or got some useful or meaningful information and insights out of this particular webinar. If you require any further support or assistance as an employer, feel free to reach out, see our website www.employers.co.nz, or give us a call on 0800 15 8000. That's 0800 15 8000.